some $40,000 at least of personal property and household goods that is owned by Jordan was removed from Ms. Hahn from the residence, including all of the information that I've provided showing the receipts for Jordan purchasing that furniture and those household goods. There's also a pool table and a backyard playset. A few things, Your Honor. The letter that Mr. Olson is making reference to is Petitioner's Exhibit 15. That's a September 4 letter that Mr. Olson sent me that says, Charity intends to move out of her residence no later than December. I'll keep you informed as to specifically when Charity is moving out of the residence so the sale can happen efficiently. But I didn't receive anything else from Mr. Olson. We found out through third parties, and Jordan contacted me to say that the petitioner had vacated the residence. Additionally, everyone knows that that is the busy time of year for Jordan. He wasn't in Kansas at the time because of his job as a professional football player, and so he wasn't able to address some of those issues at that time. It isn't something that was unexpected, Your Honor, and in fact, if you look at the order that Mr. Olson is making reference to in 2018, it was anticipated that Ms. Hahn was going to reside in that residence until Malik was 18 or had graduated from high school. So this argument that this was something that everyone agreed to or had some input in is simply untrue. In fact, this was something that surprised Jordan and I, particularly since the court had just reviewed the issue of child support and made an allowance as far as the rent for the residence. What does complicate this matter, Your Honor, is that some $40,000 at least of personal property and household goods that is owned by Jordan was removed from Ms. Hahn from the residence, including all of the information that I've provided showing the receipts for Jordan purchasing that furniture and those household goods. There's also a pool table and a backyard playset that was removed without Jordan's permission. There needs to be some offset for those costs. Additionally, the condition of the residence is such that there's going to have to be repairs and it's going to have to be cleaned before it can be listed for sale. And we need to account for those monies as well. It's not a simple matter of petitioner moved out, Jordan can sell the house, and so now he owes her some money. We need to account for some of these actions of the petitioner in removing the property and leaving the house in the condition that it's in.
If I could briefly respond, Your Honor.
I knew you would, Mr. Olson.
Okay, so, well, let's clarify a couple things. We did send a September 4th letter. There's also a letter sent on December 30th where there had been some discussions about getting the house sold and the fact that Charity had moved. This was also something that was discussed with Melissa Meyer during parenting coordination. With these parties have been involved with Ms. Meyer now for 3 years. So it was discussed and contemplated there. There was also communications in December or shortly after my client vacated the house with either Mr. Phillips or his significant other, where it was coordinated that his significant other, Warren, came up and picked up the key to the house. So these all occurred in November and December of last year. So there's been ample time, again, with respect to the house and my client vacating it. Probably more importantly, Your Honor, is to focus in on the actual journal entry of judgment, decree of paternity, and just so the courts got it in front of it, it's Exhibit 11, in our exhibit notebook. And specifically, Your Honor, it's on base stamped page 71, which would be in the bottom right corner, are the provisions that we believe are controlling with respect to this house. So Mr. Potter makes mention of furniture and some other items that were at the house that my client took. All of the items that were at the house or that were purchased prior to this journal entry of judgment, decree of paternity back in 2018. The parties were still together for a period of time into 2017 and into 2017. They have one minor child, Your Honor, Malik, who is going to be 8 years old at the end of this month. But the point with all of this and me telling you is Mr. Phillips did purchase furniture and items for this house. It's a 5,000 square foot house. It's a very big place. But all of the items that we're discussing here were purchased prior to the 2018 journal entry of judgment, decree of paternity. Why that's important is if you go to paragraph 5 on that base stamp page 71 and you look at the last sentence on that, it says petitioner is further awarded as her sole and separate property all household goods and furnishings in her possession. So all of those items would have been in her possession already in 2018. So now to come back and try to circumvent this prior agreement in order and then to say, well, there should be some offset by furniture that was previously purchased. That's the parties have already negotiated and that's already been taken care of and resolved. So I think that's a misnomer, red herring, however you want to phrase it, to bring that up now some 8 years after the fact that my client took the items that she was already awarded.
Notice how Attorney Olson uses the specific wording of their 2018 decree to justify her actions. This is a perfect example of why precise language in any agreement is critical. Court won't infer intentions if they aren't clearly stated. Ambiguous or poorly drafted agreements will cost you later, especially in property dispute.
Wear and tear and issues that have now been raised with the condition of the house, again, twofold, Your Honor. One, I find it a little frustrating that it's being brought up, at the end of February, now early March, at this hearing, when Mr. Phillips could have had possession of the house 3 months ago, and actually did when the keys were provided to him. I understand he's had work and been tied up and busy, but that still doesn't change the fact that this could have been addressed a long time ago. On that note, too, Your Honor, I'll tell you, I believe once Mr. Phillips' season was over, he's traveled for, three and a half weeks straight after the season before he was even back in Wichita, because he didn't exercise the time that he's had with Malik that's been awarded to him, which, again, understanding he has the right to travel and do things, but when you travel for the better part of a month and then come and say, well, we've just now discovered these things when we're at a court hearing, I don't think that dog will hunt, so to speak. He's had ample time. Again, not to get into the details of it, if you look at the photographs, and we did provide a video, Your Honor, as part of our exhibits. My client did a walkthrough when she's left the house. I mean, it's a beautiful home. There are some wear and tear on carpet. There's white carpet in the basement. Again, I've had the luxury of having children and having white carpet, or just having white carpet, if anybody under the age of 75, jokingly, but it doesn't take much to have the carpet need to be cleaned. I mean, there's some baseboards in the basement that I think there were pictures provided to the court by respondent where the baseboards have been removed. Well, those were removed because Mr. Phillips wanted to waterproof the basement, and they were never replaced and put back on after he chose to do that, which is all fine and well. But again, those are things that he's going to have to be responsible for. Again, it's not set out in the journal entry that my client should have an offset of her $45,000 that she's entitled to upon the sale for wear and tear on the house. It's not mentioned. And so, I think these things are being brought up to kind of distract from the fact that it's very simply set out in this journal entry that we've got back from 2018. The other thing, too, is the photographs are photographs of what the house looked like upon my client vacating here in the last couple of months. The other photographs that were provided by Mr. Phillips for comparison were the realtor photographs that were posted online. Again, that was from 8 years ago. There are some, I don't want to call photoshopping, but I think the photographs are spiffed up, is what I will call it, when you post listings online. Obviously, realtors want to have houses showing well with the people searching for homes online to schedule showings. So I think that is kind of in balance as opposed to what's being presented in the court as what's damage to this house as compared to what it looked like before my client moved in. The other part of this, too, Your Honor, if you recall, is this house was purchased for about $450,000. If you recall this hearing we had back in August with the court when this request for a rent offset was requested by respondent, the Zillow estimate, I've got a copy of it, I didn't provide an exhibit, but the Zillow estimate that Mr. Potter provided had the estimated house value being at about $800,000. So this house has gone up exponentially in value, which is great. A good investment for Mr. Phillips purchasing the house, and the house has increased by about $300,000 over what he originally paid for it. But regardless, it may need some cleaning and some additional work to get it prepared to sell. But this isn't going to be a huge. There's not significant damage to this house. There's not even minimal damage. It would be normal wear and tear, Your Honor. So again, I don't think it's that complicated. This process needs to get moving so the house can be sold and we can move on from this issue.
Potter, has an agent, real estate agent, been retained in this case to sell this property?
Not at this point, Your Honor, because if you look at these photographs, it isn't normal wear and tear. The very first one that I gave you is a copy of a cabinet door that's hanging off. It's not even functional. These are things that are going to have to be addressed. And what I would bring up to the court is that Mr. Olson forgot to read you the very next paragraph in the order from 2018 where it says, respondent is hereby awarded as his sole and separate property, all the property currently in his possession. This house is his. This furniture that he purchased is his. This was originally filed as a divorce action by the petitioner, and the parties agreed it wasn't a divorce action. There isn't anything in these documents or in the court file itself that indicates that the petitioner was to receive this personal property and the furnishings. That was never Jordan's understanding. He didn't understand that he was going to come to a house that was completely cleaned out. And frankly, Your Honor, he thought that Malik was going to live there until he was 18. So this idea that it's all set out in the journal entry according to what petitioner unilaterally decided to do, that simply isn't the case.
What do you propose here, Mr. Potter?
Well, like I said, Your Honor, I had asked for a continuance since this was just filed on Monday so that we could address the issues of how much is it going to cost to have the house cleaned and repaired so it can be shown.
And that's obviously contemplated by the parties' original agreement.
I don't know if it's contemplated by the agreement because it says it needs to be immediately sold. I don't know what
Immediately sold, immediately,
Right.
which generally is construed as without delay. We've
Okay.
already seen delay here, Mr. Potter. Immediately means immediately. Does this court need to order this property be immediately sold by public auction?
No, Your Honor.
So
It
either
doesn't.
Mr. Phillips takes care of it or the court will take care of it.
And I understand that, Judge, but at the same time, you have to look at the timing of when petitioner decided to vacate this house and turn it over to Mr. Phillips. She knows in November and December he's not going to be able to take care of these things. This is the time of year that he works. It's been that way for 10 years. She knows this. There's no reason that she couldn't have said, you know what, I'll wait a few more months until it's the off season, or even in this case, when his contract expires, when he'll be able to take care of these things himself. Mr. Olson is talking about personal responsibility and Jordan needs to take care of these things. Give him some time to do that. Why is it that we had to vacate in December, right at the what I would argue the busiest time of the year for him?
Mr. Potter, you espouse perhaps the way the agreement should have been drafted. What the court has to deal with is not that, but rather the way it was drafted and the way it was signed and approved. And none of these contingencies that you mentioned here are mentioned. It's just immediately to be sold, and she's to receive $45,000 from the proceeds. Now, Mr. Phillips can take whatever time he wants and needs if he just wants to go ahead and pay the money. It seems to the court that if he just satisfies the judgment request that's been made here for $45,000, then he can take his time in selling the property, fixing it up, doing what he needs to do. But there's no contingencies built in here for offset for personal property, for damage to the house. And absent, Mr. Potter, a common sense exception that this court would recognize for intentionally done damage, normal wear and tear would seem to be contemplated by the agreement from its inception.
Well,
Because there's been nothing that was ever contemplated to be an offset for normal wear and tear. So, I mean, it's just a straight $45,000. And I'll also note, as I think Mr. Olson mentioned, that this was a fixed amount based on 2018 prices. There's been a considerable equity increase in this property, yet her judgment amount, her interest in this house never increases. It is a fixed amount. So regardless of whether there was appreciation or depreciation on the premises, she receives not $1 more for the appreciation. But I would also note that it doesn't appear that it's contemplated that she received $1 less.
and I agree with that, Judge. What do we do with the personal property that's been removed?
Well, you apparently each have some sort of claim that it belonged to your respective clients at the time that this decree was entered. That's a separate issue than the one specifically raised by Mr. Olson in his motion, which is the motion to enforce the current court order. In other words, the current language of the court order.
Which I think would be my point, Your Honor, and why I had asked to continue it, because my intention was for the court to look at this and to make a determination as to if we should value that property, if it needs to be returned, if there's a credit that needs to be issued. To me, in the interest of judicial economy, it doesn't make sense for Jordan to file a motion in this case that says, hey, I'm looking at this order from 2018 and it doesn't give her the right to remove this property from the house. I need to be compensated because I bought all that property.
What value do you put on this property? Understanding
Well, the receipts that I
these are
provided
used
to the
items.
I'm sorry, Your Honor.
They're used items. They've been utilized in the premises by a family for 6 or 7 years now. So how much is the value as you and your clients see it?
And that's a great question, Judge. I don't know because it's been removed by the petitioner. We don't have access to it. But at the very least, if we look at the receipts that we've provided and we include the cost of a pool table and an outdoor play set for kids, it's at least $25,000. It's not nothing.
Again, again, Your Honor, I'm sorry to interject. I mean, the only thing I would reiterate is the receipts we have, the document date is 1/14 of 17. At some point in time, and this was when the parties were together, was when this furniture was purchased. At some point in time, the parties' relationship spoiled and there was separation. And at the time of the 2018 paternity that we have drafted, Mr. Phillips would have not been living at the house, would have had his own place, and the furniture was there, would have been in my client's possession. So again, I think although it's could have had a little more detail, it's actually sometimes though, less is definitely more. And this journal entry and the paternity deals with it. It would have been property that was in her possession, as paragraph 5 says. That's why I said all household goods and furnishings in her possession. Those would have been in her possession. Mr. Phillips was not in the home; he was elsewhere. So, I mean, I don't know how else that it could be clarified. It's
Him leaving his property that he bought at the home he owns does not now make it her property to do whatever she wants with. If he left something there like cars or bikes, it would be obvious how ridiculous it is to try and claim it as hers, but for some reason that same common sense isn't applied to furniture and house goods he bought for his house.
That isn't the law, Judge, on ownership of property. Jordan owned the house. Jordan purchased that property. He left it in the house. Unless the petitioner can show some transfer or some agreement between the parties that she have that property, it remains his. That's why paragraph 6 is just as important as paragraph 5.
Let us, counsel, presuppose for a moment that the court's contemplating granting Mr. Potter's request for a continuance on these issues. Let's move to the child support issue for a moment. That motion has been pending for a considerable period of time. As of today, Mr. Olson, explain to the court or reiterate for the court your position on child support.
Well, Your Honor, we had a pretty lengthy hearing with you back on August 6th, if I had my date correct, and then there was an order that was filed, I believe on October 22nd, but obviously August 6th would have been the date that mattered. At that time, the court did an offset, and what we've done is we've provided the exact same child support worksheet that we went through and did at that point in time. The only thing we have done is removed the overall financial condition adjustment offset. Why this happened, and frankly, Your Honor, bigger scale, why Ms. Hahn had to vacate or moved out of the home was that with that financial offset, moving her child support down to $2,363 a month, it was not financially reasonable for her to continue to reside in that residence. A couple of other things happened at that point in time. One order that the court did or put in place was for the parties to work together. There was an overpayment that Mr. Phillips had made for a couple of months, and the court told counsel to work through that and figure it out, which we were able to do. But Mr. Phillips wanted the payback, so to speak, for his overpayment paid off in 3 months' time. So there were a couple of months where my client's child support, already decreased by the $23.63 per month, was decreased a further $1,750 to I think $1,750 in 2 months, and then another amount of $1,200 or $1,300 the following month. I don't have the exact figure in front of me, but it became, her child support payments were substantially less than what she had been getting before, and it was not financially reasonable for her to continue living there. Another thing that hasn't been brought up, Your Honor, that was the case is the journal entry of the judgment decree of paternity mandate is that Mr. Phillips was to be responsible for paying the utilities and whatnot at the residence. That hadn't been done. My client was had been the one paying the monthly utilities at the residence. Now, I will say there's been an agreement worked out with Mr. Potter and myself. I think the overall amount of reimbursement that the parties agreed to was roughly, I want to say $37,000 that Mr. Phillips agreed to pay back. We have done it in 2 different installments, and he's made the first $19,000 payment. But beyond that, with those monthly utilities, my client having to be responsible for, it became very, very difficult, if not impossible, for her to continue to reside at that residence as well. It's a big home. I think we were talking a little bit before our hearing today, Your Honor. I think in some months during the summer, the electric bill for the air conditioning, because it has very tall vaulted ceilings, would be in excess of $500, $600, $700 a month. So leading that into the child support, all we have done, Your Honor, is run the exact same child support worksheet that was contemplated and that was filed before, but we have removed the $2,363 per month overall financial condition adjustment, and the child support that we have modified to a requesting would be $5,102 per month. Again, I try to simplify it as much as I can, but that's the gist of the argument here and what we're just asking the court to do.
And as of what date would that new support amount be implemented in your view, Mr. Olson?
Well, great question. We filed our motion on, I believe, November 27th. As we're all aware, child support is modifiable 1 month after the filing of the motion. I would put it at December 27th. It is later in the month. I mean, I think by law it could be due and owing in December of 2024. Understanding that it was filed later in the month, the court could give consideration and make it effective January 1. But again, my client's had a lot of out-of-pocket expenses that she has yet to be reimbursed for. So we would ask that the court retroactively modify it to December of 2024, which would be 1 month after the filing of the motion.
Mr. Potter, Mr. Olson's proposal has a beautiful simplicity to it.
I can already tell the judge is itching to please this woman by giving her even more money despite everything she has already gotten.
Is there anything wrong with that?
Lots of things wrong with it, Judge. Would you like me to expound on them?
Please do.
Okay. The purpose of a motion to modify child support under the state law in Kansas is that we're supposed to look at it every 3 years unless there's a material change in circumstance. When you look at the motion to modify child support that was filed by the petitioner, most of the argument that Mr. Olson just gave you is not included. And in fact, there is nothing in the motion that alleges there's a material change in circumstance. And it's very important for us to all remember that the petitioner has the burden to show that that material change in circumstance is present before the court even considers whether or not there should be a modification. That's at KSA 23-3005. And it says clearly that if we review it within that 3-year window, there needs to be a material change in circumstance. There isn't anything different now than there was when we reviewed child support last time from the petitioner's side. In fact, she didn't even file a new domestic relations affidavit. She incorporated by reference her last domestic relations affidavit. And the argument that Mr. Olson just gave you about activities and parenting time and those types of things were in front of the court the last time that we considered child support. The only difference is that the petitioner unilaterally decided to change her residence because of the court's ruling. And we would even argue, Judge, that it's not in Malik's best interest to remove him from that house because there's nothing in this motion that says that the petitioner isn't able to make ends meet. And this issue with the utilities that was just brought up, and it really folds back into one of the arguments that Mr. Olson made before. This was something that was ongoing for 7 years. Jordan absolutely agrees that he should have been paying those utilities, and he thought that he was. But instead of addressing it, he now has to come up with $39,000 because the petitioner didn't bring it up. If this was something that had been mentioned years ago, then we could go ahead and resolve it, but it wasn't. I cited a case to Your Honor. It's In Re Marriage of Case. It's at 19 Kansas Appeals 2nd, 883. It's a 1994 case, and it addresses an issue of voluntary termination of employment, but it has a bigger discussion as to voluntary actions by one parent, and the court clearly says that if a voluntary action issue comes to be, the parent's actions should be considered suspect when we're reviewing child support. The order that was filed in this case was in October. The only thing that changed was the voluntary action from the petitioner. That's not a material change in circumstance. If you remember, Judge, when we were here the last time, it was because Jordan had his income reduced by 65%, and he was exercising more than 35% of the parenting time with Malik. Those are material changes in circumstances, and the court agreed. The only thing that's included in this motion today is that petitioner decided to change her residence, and since she's no longer living there, we need to remove the credit that the court gave to Jordan as far as owning the home. That's not a material change in circumstance. And it's very clear that the motion was filed to get around what the court ordered last time. Judge Malik is 7. This is the only residence that he's ever lived in his whole life. I don't have anything in this September 4 letter from Mr. Olson that says that Charity just can't make ends meet because of this reduction in child support. There's nothing in this motion that indicates that. Jordan was paying for the house and all of the utilities, or now is paying for all of the utilities. This issue, as far as collegiate is concerned, he pays for all of those expenses as well. If the argument is we have to get this kid to and from his activities, I'm sure that we can resolve that because Jordan is exercising parenting time now. So it's not for the entire school year as far as any of these issues are concerned. But if we also want to continue talking about a material change in circumstance, as we said at the last hearing, Jordan's contract expired this year. He's not presently under contract to play for any team. He doesn't technically have an income because he hasn't signed with any teams. He's played for 10 years, and if a contract is offered to him, and then he is going to consider that. But as of today, that contract and the amount of money that Mr. Olson has in the child support worksheet, that's not there. He doesn't have that income going forward. If we would need to review this in the future, if Jordan goes ahead and takes a contract, or if we need to look at his employment after today's date, we can certainly do that. But to adopt a child support worksheet today based upon an amount of income that is directly reflective of a contract that has expired, that isn't proper, Your Honor. What we're supposed to do is look at what Jordan's income is at the time and make an adjustment as to child support. If anything, there's a material change on Jordan's end. So there isn't a material change in circumstance to warrant a modification in child support, because the only change since the last time the court looked at this was petitioner's unilateral decision to move from the home. But even if the court was going to review that, then we also need to consider the fact that Jordan doesn't have an income going forward, and we would need to adjust child support accordingly from, I would say, March 1, and then review it if he does enter into a contract to play football from this point forward, or if his circumstances change as far as income is concerned. What makes more sense, Judge, and actually what's going to be better for Malik, is to leave child support the way that it is now, so that we can then address it in the future when we have a more definite picture of what